Each side will have, let's wait for the strawberry. All right, each side will have 15 minutes to present their arguments, and the appellant may reserve up to 5 minutes.
Thank you, Your Honor. Attorney Neil Agarwal, representing the appellant, Michael Odo. I do reserve 5 minutes for rebuttal. Your Honor, the facts of this case are not really all that much in dispute. Summit County Children's Services filed a complaint alleging dependency. The court obtained dependency, worked with the parents to work on a case plan. At the end of the case, both mother and father filed motions for legal custody. The trial court granted legal custody to the father, to the mother, and granted visitation to the father. The magistrate did. And in the magistrate's order, she gave the father 3 weekends for visitation. Father filed objections, and the judge upheld legal custody to the mother, but changed the visitation from 3 weekends to every weekend. There was no exception for the mother. So father had every weekend visitation. Father then appealed to this court. And while the appeal was pending, the trial court issued a non-pro-tunc, changing the visitation again, and then father re-appealed that non-pro-tunc to this court. It was consolidated. This court upheld the finding of legal custody to the mother and threw out the non-pro-tunc that the trial court issued while this case was pending here, saying that was defective. So the trial court's order at the end of the appeal, the first appeal here, was dad had visitation every weekend. And father never raised any issue regarding that visitation order. Mom never raised any concern or issue regarding the mother's or father's visitation order. So we're arguing, okay, and let me get back to the fact. After this appeal was ruled upon, mother pro se immediately filed a request to the trial court to now issue a new non-pro-tunc, and the trial court granted it without a hearing, without testimony, without evidence, and said, and she didn't adopt what the magistrate originally did of the first 3 weekends. She just said the 4th weekend will belong to the mother in the month. Other than that, everything else is the father. Now, you may say, well, what's the difference? There is a significant difference between what the magistrate ruled and the trial court's non-pro-tunc. In the magistrate's original ruling, the first 3 weekends were the dad, and the rest were the mom. Under the judge's non-pro-tunc, filed months later, 14 months later, dad had every weekend but the 4th. And what is the significance of that? Some months have 5 weekends. Under the magistrate's initial ruling, that 5th weekend would belong to the mother. Under the judge's non-pro-tunc, that 5th weekend would belong to the father. So those are the basic underlying facts. Now, to my first assignment of error, mother, after this appeal was decided, she filed her own pro se motion. At all times throughout the proceeding, we're arguing she had counsel appointed to her. And she didn't serve me, she didn't serve the guardian ad litem.
Based on what? You're arguing she had counsel appointed to her at all times based on what? When did appointed counsel's appointment end?
I am arguing that appellate counsels, when the appeals are done.
What about the trial level?
She had a counsel appointed who stayed on through the appellate process.
Okay.
The trial court appointed trial counsel at the trial level who stayed on during the appeal.
And that counsel was counsel for everything?
Correct. Correct. It was appointed by the trial court to represent her on all appellate issues from the juvenile court. So we're arguing that, first of all, while the appeal is still pending, and I know there's an issue about that too, that she had appointed counsel, and only appellate counsel could have filed the request for a non-pro-tunc. And then second of all, she didn't serve me. I was always dad's attorney throughout the trial in the appellate level and at the Ohio Supreme Court. she didn't serve the guardian ad litem. So we're arguing that these filings by the mother were defective. Now, then moving on to my second assignment of error, and there's very little case law regarding the second assignment of error. And the question is, once this court makes a ruling, either side has basically 45 days to decide to appeal to the Ohio Supreme Court. I am arguing that is still at the appellate level, and the trial court is without jurisdiction to make substantive rulings between this court's final decision and the time to appeal to the Ohio Supreme Court. Now, I couldn't find, and neither side could really find any case law one way or the other. And the reason I'm arguing is because if Dad has 45 days to decide to appeal, which he did in fact do in this case, is that the trial court can issue all sorts of rulings at the conclusion of this case that could impact the Supreme Court ruling. So, or our appeal, I should say, to the Supreme Court. So the Supreme Court then would be ruling on a case that may become moot or might have changed substantively after this appeal was decided, but before it went back to the trial court. So we're arguing as a matter of law that the trial court could not issue any ruling while the appeal was pending. And to us, pending means not only that 45-day limit after this court's decision, but of course that there's a filing at the Supreme Court until the Supreme Court resolves that appeal. And in this case, it was appealed and the Supreme Court denied review a number of months later. Moving on to my third assignment of error. Because mother did not object or raise any assignment of error regarding the visitation of Dad getting every weekend, and that was a ruling by the trial court, that is res judicata. That is the law of the case. You can't issue a nunc-pro-tunc to change a ruling that nobody appealed from. The mother was fine with that ruling, or she would have raised it as an assignment of error. Father didn't raise any objection to the visitation order. He was raising objections related to legal custody. He wanted custody, but if he lost custody, he was fine with getting visitation every weekend. Now, the trial, and this court never remanded the case back to the trial court. Everything was affirmed or vacated. There was no, we're sending it back to the trial court to make further rulings. So the jurisdiction was never regained by the trial court at any point to make any changes. So we're saying, how in the world could the court issue a nunc-pro-tunc to a decision that was already affirmed by this court? This court has held if you don't raise an assignment of error, it's res judicata. You can't be heard to complain about something that you could have raised timely through a notice of appeal. If mom didn't like the visitation order, why didn't she appeal it? If she was fine with it, then why is she complaining now that I want it changed? She can't have it both ways. And then finally, in my fourth assignment of error, Your Honor, I'm arguing, in spite of all those previous assignment of errors, the judge could not issue a nunc-pro-tunc in the facts of this case, because father had every weekend visitation, and then if she issues a nunc-pro-tunc after this court's appeal saying, well, I'm reducing Dad's visitation effectively by 25%, he not only has, he has lost one weekend each and every week. And if I'm ignoring the fifth weekend for mathematical purposes, that's basically, instead of 4 weekends a month, he has only 3 weekends. That's a 25% reduction in his visitation. The judge issued this without a hearing, without notice, without ability to contest it, because she's claiming, I mean, as a nunc-pro-tunc, it's a clerical error. Well, we never had a hearing before the judge when she ruled on the objection. She just read the transcripts, made her ruling, affirmed it, and then she said, well, I made a mistake, it's a clerical error. But a clerical error has to be apparent on its face. Now, the mother's attorney is saying, well, it was just a typographical error. She meant to adopt whatever the magistrate did. But if you go by that theory, the judge didn't even do that. The magistrate was the first 3 weekends belonged to Dad. That is not what the judge wrote when she wrote her order. She said, every weekend is Dad's but the 4th. And that is not the same adoption as the magistrate's ruling. So with that, I would reserve the balance of my time and ask the court to throw out the nunc-pro-tunc. Thank you.
Thank you. Well, this case is somewhat like asbestos litigation. It just continues. We've been here once before, and in fact, we were in court last week, earlier this week, on this case again. So it's just, it's an unfortunate that it continues to go as it is, but it has, and it probably will. To address some of these issues that are presented, my name is Dave Lowry. I represent the appellee in this case. I was here previously on the previous case also. But with that said,
And counsel, I neglected to tell both of you, to remind both of you not to use children's names.
oh, okay, I'm sorry.
No,
Oh, I haven't used it yet.
You haven't used it, that's why I'm trying to do a preemptive strike.
Okay, good. Okay,
And
thank
stay behind the podium.
I'm ahead of the curve then.
Yeah, we're videoing, so you.
Okay, very good.
Do
First of all, and I'm going to take them out of order just because I don't remember the order, but let's talk about this right representation, which Judge Callahan properly brought. And as I discussed in my brief, appointed counsel isn't a legacy, which is the approach that I think counsel's taking. That once you're appointed, you're always appointed. I was appointed in the underlying case, and I was appointed in the Court of Appeals case. The Court of Appeals case was done and had been resolved before my client filed a pro se motion, okay? I filed a fee app that was approved by you. Attorney Argywall filed a fee app that was approved by him. My understanding has always been when you file a fee app, the case has been terminated. Attorney Argywall's position is that notwithstanding that fact, that he continued to be on the case apparently forever, until at some point in time, I'm not real sure what the defining moment would be where he is no longer counsel. But certainly there, once the appeal was done, because if you take a look, and I think maybe that's some of the confusion here, the Court of Appeals decision was rendered on September 20th. The client filed a pro se motion 9 days later, and she did serve Mr. Odo. Okay, and the court notates then the court issued the non-protunct entry shortly thereafter on 10/10/2017. And if you take a look at the court's notice, the court only sent a copy of that to my client and Mr. Odo. The court didn't send it to the guardian ad litem, or the court didn't send it to Mr. Argywall. So really the issue that's germane, and I think it's an interesting one, and I can't find any really direction on it, is when does representation end? I mean, during the pendency of this, Mr. Odo has filed additional motions, and we've been in court on additional motions, and I believe the perception is that this representation continues throughout the time period of an appeal, which is an interesting concept to me because the appeal could take in excess of a year. So is the presumption then that the client continues to be indigent and doesn't have to reapply, doesn't have to get new appointed counsel, and that sort of thing? It's an interesting issue, and quite frankly, I'd like clarification. When does your representation end? My perception is my representation ended at the time the appeal was issued without remand, and my client had full right and authority to file a motion if she wanted to on a pro se basis. So and it's not hybrid representation, and it's I think it's the Clayman case that counsel cites, and if you read the facts of that case, the case is entirely different than this. There's no relevancy, there's no overlap or anything else. This was not hybrid representation. It was simply somebody that was filing a motion subsequent to the case being terminated with the issue of non-protunct. So she had the authority to do it. It's not hybrid representation. I didn't have to do it. In terms of service, if you take a look at the 60A, 60A clearly says, and I guess this transitions into my other argument, is whether or not the court could issue the non-protunct order, the October 10th non-protunct order. 60A clearly says that the court, that an oversight or omission may be corrected by the court at any time on its own initiative or on the motion of any party, and after such notice, if any, as the court indicates, they can issue the order. Now, this case is somewhat interesting because the real issue that this court needs to determine, and this goes also to, there was an interim request before we briefed this case. The court asked us to address the issue of a substantial modification or substantial change. Counsel argued there was. I argued there wasn't, because my argument, I guess, is somewhat esoteric in that my argument is that there really was no change because it is what the court clearly envisioned from the beginning, so therefore, if it was envisioned at the beginning, there can't be a change because there was no change from anything but what was anticipated by the court at that time. And in that regard, I think that if you take a look and you read the October 10th, 2017 non-protunct entry, which was the non-protunct entry that was responsive to my client's pro se motion, if you read that, it clearly and unequivocally goes through the facts, and it's clear that Judge Teodosio, she says the court attempted to amend the entry on September 22nd, that's the entry that you deemed to be inappropriate, and that this court found that there was not jurisdiction. And she specifically says in that case that the court attempted to amend the entry pursuant to Civ Rule 68. So the court, what the court's telling you there, and then the court goes on to say that the 9th District held it void, and the mother's requesting court reissue, and then it says that to do it non-protunct, correcting the error in the previous entry now that the matter has returned from appeal. On its face, it is absolutely and abundantly clear that this court recognized that it made a typographical error in its order. And if you read the order and compare it against the magistrate's decision, what is apparent and obvious that there was a parenthetical left out of the visitation, where she talks about the visitation, but the court tells you in the October 10th, 2017 entry, hey, we're not making a substantial change. What we're doing, we're not making a change that we change our mind either because it made a legal or a factual mistake in making its original determination, or on second thought, it decided to exercise its discretion in a different manner under the Kuhn case, which is 55 Ohio Appellate 3rd, 245, 1988 case. What it's telling you there is, listen, we screwed up. We made a typographical error. We tried to correct it before. We couldn't do it because we didn't have jurisdiction. But we're doing it now because we want to correct the record, because that's what we think the record reflected, and that's what happened. So I'd ask you to revisit that October 10th entry, because it says everything there. And to sit here and suggest that the court changed its order, that's an anomaly. I mean, that's silly. And if there's no way that you can come to that conclusion if you read the October 10th, 2017 order, where Judge Teodosio tells you, listen, we made a mistake, and we're correcting it now to reflect the record properly. Moving on. Attorney Argywall is correct. What he's asking to do is something that's not reflected in case law, and what he's asking this court to do is to create some sort of an automatic stay between the time of a decision of this court and the appeal period for the 45 days for a Supreme Court appeal. What he's asking this court to do is say, listen, we're going to create some sort of a decision that says that after an appeal comes back, you can't do anything on a case for the 45-day period, because we have to wait until to see if you file an appeal with the Supreme Court. And I would suggest to you that if that's not something that this court or any court can do. My perception is that that's something that would have to be done legislatively, and that's something that is beyond the purview of a reviewing court, to make a decision like that. It would be a creation of an automatic stay between the time period of an appeal in the Supreme Court, and I don't think there's any foundation for that. I think it's a dangerous precedent. I think that that there's no case law that supports such a notion, and that, Attorney Argywall's position that there's things that could happen in there, sure there are. And your remedy, I suppose, would be to either file an appeal or file objections or something else, but there's nothing, to the best of my knowledge, in case law or the rules that suggest that there's any basis to adopt that stance. With that said, do I get to keep some time or not?
No.
No, I don't get. How much more do I have?
You have 5 more minutes. You don't have to use all your time.
You just want to go to lunch. That's okay, I understand. Finally, I guess I would talk about one more thing. The court has the inherent ability to correct its docket, its clerical errors, and its mistake at any time. And that's what happened in this case.
Does
The
he have the
court,
right to do that while it's on appeal?
not on appeal. Yeah, and that obviously.
Even if it's a clerical error?
Well, you said what? You said no. In Ray, I won't use the name, but the case that you've already decided, your decision was, it was kind of interesting because you put a footnote at the bottom, somebody did, I forget who penned it, but there was a footnote in there that says you can't do a non-proton entry during the pendency of the court without leave of court. And then there was a footnote down there that says, because father didn't argue the application of 60A, we won't address that issue. So I guess in some respects, perhaps this court left open the availability, or at least the issue or the argument that an argument could be made under 60B that the court could issue some sort of an order that would affect the previous order. But the basic finding of this court was that there was no jurisdiction during the pendency of that time to file a non-proton order. And then this court actually voided that order, and then it went, then that was the need then for the October 10, 2017 order that the court issued to correct what was obviously a clerical error. So I'd ask you, I think that entry is real important because it tells you that, listen, we're not invoking any substantial change. We're not making anything that is other than the fact that we made a mistake. We made a mistake and we're correcting. We tried to correct it the first time. We weren't able to, and the Court of Appeals told us that. But we're going to try to correct it this time. And I would suggest that under 60A, in the court's inherent power, they had the ability, and that order is valid and existing.
It's a little bit more unusual, though, than a usual 60A.
Judge, this case has many issues that have been issues that, and I think Attorney Archibald will agree with me, this case has a lot of issues that have been unique and different. I don't disagree with you. It is a little different than the way, I hope I never see another non-proton entry. And it is a little different, but I guess, and I take a look at what the law is intended to be. I mean, there's the law, and then there's what makes sense with the law. And at some point in time, I mean, is the law so structured that a court can't fix what they screwed up, and they acknowledge that they made a mistake that is a clerical error or whatever, because of, I guess there's the right and the wrong. And it seems to me that the court, when 60A and the law says the court has the right to fix its docket and change things and inherent ability, it seems to me that notion of an inherent ability, if it's supported by the record and by what the court has said, I guess I'm one of those guys that think that trumps procedure. I guess is what I'm advocating. With that said, I appreciate it. Thank you.
You have 5 more.
Thank you, Your Honor. May it please the court. I do agree with Mr. Lowry that I am saying there is really a 45-day stay. And again, he says there's no case law. Well, that is true. There's no case law to support really my position. There's no opposing case law to support Mr. Lowry's position. It's almost a matter of first impression. At what point can a trial court rule after a decision from this court during the appellate process? And I am asking the court to make a ruling that the trial court cannot take actions while the appeal is pending. As far as the first assignment of error, appointment of counsel, under the theory of Mother in this case, in any civil litigation, if there's attorneys involved and there's a decision, plaintiff wins or defendant wins, and the other side appeals, if the plaintiff wins and the defendant appeals a civil judgment, who does the defense attorney serve? They don't serve the plaintiff if they're represented by counsel. They serve plaintiff's counsel if they have one. under the theory he's espousing is that once the trial court makes its ruling, those attorneys no longer represent that party in civil litigation. If I was the defense attorney and I'm appealing an adverse ruling, I would have to serve the plaintiffs directly, because we have no idea if those attorneys represent the plaintiffs for the appeal.
Well, counsel, but we do have that situation in some places in our district where in the permanent custody cases, after the permanent custody hearing is over and the attorneys are no longer responsible for filing the notice of appeal. And then we've had situations where no notice of appeal is filed and it's late, or they file it late, I should say. So that kind of cuts against what you're arguing, doesn't it?
No, and the reason is I'm talking about your representation of your party may end. I'm talking about the other side, when they decide to file the notice of appeal. Am I serving children's services directly, or am I serving the prosecutor? If I am the mother's attorney, do I serve dad's attorney in the filing of a notice of appeal, or do I mail it directly to dad? Dad's attorney may say, I'm done with the case and I don't want it, but I have a responsibility to serve dad's attorney when I file my notice of appeal, because as far as I understand, dad is represented by counsel and I have no ability to interact directly with the opposing party if they have a representation by counsel. So I'm arguing that I had no ability, mom could not file her pro se motion. Well, even if we say Mr. Lowry did not represent her after this appeal, I still represented my client. The guardian ad litem was still the guardian ad litem.
How did you represent your client? Were you appointed for the appeal?
Yes,
And was the appeal finished?
I would argue,
Was the appeal finished?
I would argue no, Your Honor,
How?
because the appellate process was not finished.
Was a decision issued?
Only from this court, yes. But that to me is
So
not.
you're back to your 45 days?
Yes,
Okay,
yes.
all right,
And I'm, right,
all right.
during that,
I follow you.
right, after that 45 days, if father did not appeal, then, and I was appointed, I'm done. I'm not his attorney, I'm not this legacy attorney, I'm 6 years later, the kid's still a minor, he comes.
You're also outside the deadline for turning in your fee out.
Right, right, but,
Just saying.
right. And then finally, the last point I want to make is, after the judge issued its original ruling giving father visitation every weekend, father appealed. If mom filed her own cross appeal and claimed on appeal the trial court erred in giving father every weekend, and this court affirmed that ruling, could the trial court then issue a non-protunct saying that's not what I meant? We would say no, because this court issued its ruling on their assignment of error regarding visitation. What is the difference in this case? Mom did not appeal the visitation order. She was fine with it. When the judge issued its ruling, they could have appealed and said that was an error. The fact that they didn't appeal, it's a benefit that the judge can now issue a non-protunct because they chose not to appeal that ruling. It is res judicata. They could have and they should have appealed the trial court's visitation order if they were not satisfied with it, or they did the trial court error.
Unless they thought it was a clerical error that could be remedied by non-protunct.
And if they thought that, they should have asked this court, may we have permission to do a non-protunct? They chose not to do that either. So by not doing it, the non-protunct on appeal was defective, the non-protunct afterwards is defective. So they didn't comply with the civil rules or the appellate rules and ask for the non-protunct. I think it's too little too late at this point, so.
And counsel, you're out of time.
Thank you.
Thank you. Thank you both for your presentations.
Thank you.
The court will take the matter under advisement, and we will issue a written opinion that will be sent to you, as well as it will be released on the website of the 9th District, as well as the Ohio Supreme Court. Thank you, Judge.